Blake Lively and Justin Baldoni's case has kind of gotten a little bit derailed. And listen, there is so much chatter online, and I'm gonna just stick here and focus with what I know and what is relevant to the topic. And while there's been a lot of discussions about the ruling the judge made about this motion to dismiss granting a lot of it with prejudice, with many people pointing out the issues with the judge, which I shared on an Instagram post about some of the conflicts that he has. However, even with those conflicts, seeking a recusal of him at this point would have to go through the appeals court, because if they ask the judge to recuse himself, he's not going to do it. And also they have to get a couple bad rulings before they can really prove to an appeals court the grounds that they have for why he needs to be recused. And at this point, the motion to dismiss with prejudice is a problem, but it's not really an issue of law when it comes to anything that the Supreme Court might be interested in. So think of it this way: if they do a motion to dismiss and they appeal it, the result from the appeals court goes back down to the district court. Justin and his team can't kick it up to the Supreme Court if the appeals court doesn't rule in their favor, because the current issues they have with their motions to dismiss don't really have to do with any sort of constitutional issues. The big issue they have has to do with 47.1. And I would suspect that if there was any sort of sanctions granted under that law, that would be something they might appeal. But right now they have to be careful, because appeals take time, and they take time away from the case. So getting away from what's happening with the judge and conversations about his recusal, which I really don't think are helpful right now. I know initially I posted that on my Instagram, but, and I know everyone's trying to point me to these different videos, but it doesn't matter to me right now, because what matters is that I don't think this case is going to go to trial anyway, and I still believe Blake is trying to get out of this case, and there's a few things that have happened this week with Blake that I think proves that her one case is very weak, and two, she just literally overnight dismissed 2 of the counts against Justin and Wayfair ones that she had been arguing with them previously about whether or not she was going to dismiss them. We got an answer from the judge about garden variety claims, and she's clearly sweating about what's going on with Taylor Swift. So let's kind of de-talk about those specific issues, because that's where I'm at right now. So Blake Lively last night, she filed a stipulated order and agreement that she and Wayfair came to about those intentional infliction of emotional distress and negative infliction of emotional distress. Now these 2 claims are needed to prove damages, and if she wanted to use medical records and get the maximum amount of money she possibly could for each of the claims against Baldoni and Wayfair, these medical records would have given her the best opportunity for punitive compensatory and damages related to emotional distress. Okay, and she has waived these. Now Blake has kind of an uphill battle here, because you need to have an injury, an emotional injury, in order to prove that SH was severe and impacted her life, and that the retaliation also caused significant injury. If you can't prove injury, you truly can't get awarded damages. So we know that she doesn't have proof for her retaliation, and we also know that the SH claims are very, very, very weak in terms of what she claims to be sexual harassment. But the stipulated order that she filed in court says that it's hereby stipulated and agreed by between the undersigned attorneys for the parties to the above caption actions. Plaintiff Blake Lively hereby withdraws and dismisses the 10th action and the 11th cause of action of intentional infliction of emotional distress and negligent infliction of emotional distress asserted in her amended complaint with prejudice, with each party to bear their own costs and fees, and without the withdrawal or dismissal of any other claim, counterclaim, or third-party claim. Asserted here, it is further stipulated and agreed that this stipulation may be executed in counterpart and electronic or facsimile signatures, shall have all the same force and effected as originals. And then all the parties on every side that were involved in this case agreed to this dismissal. So this is effective today, those are gone. Okay, and it's with prejudice, meaning she cannot bring these back. Okay, so the judge said that she can do garden variety. Now garden variety means that she'll be able to tell the court, listen, I got humiliated, I felt like anxious, I had a hard time sleeping, I got really emotional, I was very sad, but it doesn't allow anyone to share a diagnosis. Say that this caused her PTSD that's gone now, or a mental healthcare provider, or her doctor, or an expert witness, it's out. She can't bring any expert witnesses to speak to her problems that she's had as a result of this, so it's a big blow. But I want to give you kind of an understanding of what's even more shocking to me about all of this is that, Blake has been up here and crying up and down about how much money she's going to make. There's a couple issues, you guys. One is that we know that Blake's Title VII charges that she filed for discrimination on in federal court are barred. She did not file a charge with the U.S. Equal Employment Opportunity Commission, which is required before you can ever file a lawsuit in court. The reason why she knows the reason why we know she didn't file one is because when she got her letter from the state of California, she did not seek joint filings. So in California, there's an option where if someone files a complaint with the CRD, they will jointly file with the EEOC on your behalf. But she didn't do that. She didn't tell them to file it with the EEOC instead. She only filed it with the state of California, and then the state of California said, well, if you want to go into federal court before you do, you need to contact the EEOC within 30 days of this letter. Well, we know that instead of contacting them, she filed a lawsuit in federal court 11 days later. And the reason why we know she'd never filed a charge with the EEOC is because you would never get a right to sue immediately with the EEOC, in fact. In order for the EEOC to do an investigation and give you an A right to sue letter, they have to do an investigation, they have to contact you and notice your employer. They have to first go through the entire process, and after 180 days, then once they have an administrative decision, or if it's going to take more than 6 months for them to figure this out, they will give you a right to sue. Meaning the first opportunity she would have had to sue would have been in May of 2025. So think of it this way, the 2 first counts of her lawsuit are also dead in the water because she doesn't have permission from the court. Eventually this issue will be brought up, whether it's from Prairieman or by a judge, because we haven't gotten to that part yet. But even if she had a right to sue, there are serious limitations in terms of how much money she can make under Title VII. The federal government limits compensatory and punitive damages for employers that have less than 100 employees to $50,000 per claim. Wayfair has less than 100 employees. Okay, so the max she could get for the first count for compensatory and punitive damages is $50,000. The maximum she can get for the second count is $50,000. That's the limit. These are not claims that are going to get her a lot of money. And then if you put in garden variety for why you're going to claim for your claims, it's going to reduce the amounts even more. Blake really was banking on making the bulk of her money on dismissing the case and having a judge award her treble damages, punitive damages, and all of that, which could be in the millions. So her case itself doesn't have huge numbers anymore. It's limited by the amount of money that is set by the federal government, and then California has their own guidelines for the max amount that can be awarded for these kinds of claims, and she's not looking at millions of dollars in damages, which kind of to me explains why she's been running up the cost in all of this, because the more she can get them to pay her now, the more she spends now on the case, in motions and emotions to compel. That is what her attorney's fees are, and then they can triple that. And that could be millions of dollars. She has absolutely no intention of bringing this to trial. I just want to tell you that. And then another motion filed this week, and it has to do with Taylor Swift. Blake's attorneys are telling a court that they have zero interest in handing over communications with Taylor Swift to Wayfair, because they're saying that Welfare is asking for Blake's communications with Taylor Swift and Ryan's communications with Taylor Swift, but they haven't produced to Miss Lively the documents they claim to have received as a part of a deal to withdraw their subpoenas to Miss Swift and her counsel. And then she goes on to accuse Baldoni of using Swift for clickbait, even though I'll share with you an article that came out today by Taylor's insiders, likely her publicist, saying the only person using her for clickbait was Blake. But she wants them to give up anything that Taylor gave to him to Wayfair. And what I find interesting is this letter is signed by Ezra Hudson. Okay, and Ezra, not Michael Gotottle, is filing this. Because if you remember, some of the communications that were alleged to have been thought by Wayfair had to do with some email that Gotottle sent to her attorneys. So again, it's not Gottlieb asking for this. It's Ezra, and then Ezra claiming that Wayfair is the one that is using Swift for clickbait. They said that throughout litigation over the past month, they have Wayfair has repeatedly used Miss Swift's name as part of their media strategy after serving requests for productions 108 and 109. This court is aware that the Wayfair parties served a subpoena pursuant to Rule 45 on the law firm Venable, which has served as outside counsel for Miss Swift for communications between Miss Swift's lawyer and Miss Lively's counsel. So they want that communication. The Wayfair parties subsequently served a Rule 45 deposition and document subpoena on Miss Swift that sought documents and communications entirely duplicative and cumulative to those they sought through 108 and 109 for Lively and Reynolds after nearly 2 full weeks of tabloid coverage on the subpoenas, as well as other now-stricken filings on a related topic which we all know about, right? An exclusive article came out by the Daily Mail, and it says, Justin Baldoni's attorney, Brian Freeman, dropped the request for the subpoena, and the reason for doing so is simple. They got exactly what they were seeking, sending a subpoena to Taylor, and Taylor's response has provided Baldoni's team with everything that they needed. Taylor stated that she was not involved at all, and this is in stark contrast to what Lively has said. And then the insider said, Taylor was always considered to be the smoking gun in this, and everyone is extremely pleased with the end results. And the information it yielded, they got exactly what they were hoping for, and much more. So did they get documents? We don't know. Did they get statement from them? Was there a possible declaration that they received maybe? But we really don't know. I mean, maybe there was just conversations, and then they're referencing Friedman speaking to Megyn Kelly whether or not they need evidence related to Swift in addition to what he already has. And they said that Freeman recognized he may not need that evidence related to Swift in addition to what he has already, if they already have obtained exactly what they were hoping for and much more, and do not need any evidence in addition to what they have obtained, then RFPs 108 and 109 are duplicative, cumulative, and unnecessary even more. The only allegations in this action that were ever remotely related to Swift were the Wayfair parties' now dismissed complaint. She's not mentioned a single time in her Lively's amended complaint. That's actually true. I don't know what's going to happen if they amend their complaint. If, Swift's name is going to be brought up again, I have no idea about that. But on May 22nd, they emailed Wayfair about the public statements, and they said they interpreted the statement to mean that either the intent of their party subpoena, since our understanding is that they obtained no discoverable materials, as part of this process was to introduce scandalous allegations about Miss Lively and her counsel into the public domain to generate negative stories, or they had received materials responsive to their subpoena, which would come as surprise given that no materials have been provided to us. And it could mean neither of those. I hate when attorneys send these kinds of letters, because it's just a way to manipulate it and say you either did this or you did that. And sometimes it's maybe you did. Neither the same email explained that any discovery that the Wayfair parties or their counsel obtained concerning Miss Lively from any third party would be responsive to properly served RFPs, and they have not responded to the email. They have not produced any productions from Miss Swift. Further, the parties have an agreement to produce documents obtained via third-party subpoenas to each other promptly upon receipt, which would clearly apply to these documents, if not any notwithstanding the withdrawal of subpoena. So they are again using this to accuse Wayfair of seeking sensational headlines, which they've already done like 13 times, and they want a protective order. And if they receive documents from Miss Swift such that they have exactly what they need, then the discovery saw it in the ones from Brian and Blake is unnecessary and don't need to be produced again, and they want, on the other hand, if they're seeking only sensational headlines by serving subpoenas rather than materials to support their claims and defenses, they are not entitled to information under 108 and 109. So apparently, on June 9th, the same day that the motions to dismiss were granted, Miss Lively, her counsel spoke to Wayfair, and they wanted to, or they sent an email about having a conferral about this dispute. And then during a conferral on a separate issue on Tuesday, the counsel asked Wayfair, what their position on 108 or 109 was. And really what they said was that they didn't want to talk about it yet because they didn't really know they weren't ready to discuss. And it's been 80 hours since, and she requested the confer, and they haven't responded that the purpose was not to obtain discovery, but rather reports is consistent with statements by counsel to Ms. Swift that they have not produced any materials of the parties, no documents are being produced, and no deposition is being scheduled. So what this letter honestly tells me more than anything is that she has absolutely no contact whatsoever with Taylor Swift or Taylor's attorneys. And they shared some exhibits in here that I thought was interesting because the fact that she's running to the court and saying, well, I want to know what you have from Taylor, means they're not talking to Taylor. It means Taylor's attorneys are not talking to them. It means communications between Taylor and Blake's attorneys. And Taylor's attorneys is non-existent. And so they are having to go to a judge and say, I want to know what they have. They may or may not even have documents. We don't really know, And if, say, it was Scott Swift that handed over the records, if he wasn't subpoenaed, they don't have to give it to Blake. The only agreement that they made had to do with subpoenas. But if someone gives information willingly to someone without a subpoena, Blake can't demand it from them. According to the agreement they told the court, existed something that was particularly interesting to me was that one of their exhibits had to do with an email string between Venable and all the parties of this lawsuit and the communications that Lakes' team sent to them after, and then the non-response they got. So Venable notified everyone in the part in this lawsuit, literally everyone, not just Blake's team, but everyone. And they said today, Venal filed the attached motion to quash the April 28th subpoena in the United States District Court of District Columbia. The motion and other ancillary documents that were filed today are included in this following ShareLink file. Additionally attached, please find responses and objections to the April 28th subpoena to Venable. And immediately once they got that, not immediately, a couple hours later, Blake's attorneys were like, as you are aware, we just served a copy of Venal's motion to quash filed in the above caption matter relating to subpoena issued in connection with Lively Wayfair Studios. On behalf of Blake Lively and Ryan Reynolds, we intend to file a motion to intervene in the above caption matter prior to tomorrow's deadline for subpoena compliance, along with a motion to quash. Please let us know by the end of the day today of your position on our motion to intervene. So they notified them on Monday, May 12th, Venable, listen, you're getting a motion. We're quashing this motion. A couple hours later, her attorneys contact Venal and are like, please let us know what you think about our intervention. We're gonna fight for you. Well, guess what? They never responded. 10 days later, her attorneys sent an email to everyone, which said, please be advised that Venable's subpoena and the Taylor Swift subpoena have been withdrawn by counsel for the Wayfair parties. Without prejudice to them, timely serving subpoenas in the future should they decide to do so. All parties reserving all rights. No documents are being produced, and no deposition is being scheduled. Accordingly, we will be notifying the court that our motion to quash is moot. Thank you. So when they withdrew the subpoena, they didn't produce any documents. They didn't schedule a deposition for Taylor. But if in the future they needed to, they could refile the subpoena because it was dismissed without prejudice. So we don't know what, if anything, was produced, or if conversations they had made them aware of and gave them what they needed. Documents being produced and a deposition are far, far different than having a conversation to find out what happened, right? And say, Scott Swift gave them information or gave them emails. I don't know. But either way, what all of this tells me more than anything is that her attorneys didn't respond to Blake and Ryan trying to intervene on her behalf. They didn't say a word that tells you where the relationship is between Taylor's side and Blake's side. Her side then worked with Wayfair and worked things out. No conversations occurred between them and Blake's team. So Taylor is not speaking even through attorneys. To Blake's attorneys, at this point, they're trying to intervene. I don't believe to protect Taylor. They're trying to intervene to protect themselves. And clearly they want to know what Taylor's team gave them. Why else would they be filing this now? Because Wayfair didn't even say they wanted it immediately. They didn't say anything of the sort. Her footnote says they weren't ready to talk about it because they didn't know, because their case literally just got dismissed. They're in the process right now of putting together a new amended complaint. And at this point, they need to figure out what information is relevant and what's not relevant. But it's Blake right now and her attorneys that are sweating about what Taylor's attorneys spoke about with them and what Taylor might have shared with them. So there's no friendship here anymore, which is what I've told you now for a couple weeks. But after this came out and Blake is again trying to make it look like she cares about Taylor, they released this article this morning. So this isn't a coincidence. Taylor Swift has ditched Blake. There's no way back for their friendships. She will forever be furious. And it has to do with what Blake did to Taylor, not Justin. Even though there's a part in here that kind of frames it. Like it's Justin's fault, it's not Justin's fault. Don't shoot the messenger is what they always say, right? So here's what her the source said. Taylor buries hatchets but keeps maps of where she puts them. Remember in text exchange, Livy referred to her as dragons, comparing herself to the character Casey. And this is why Taylor's mad at her. And I'm telling you, this is exactly what I told you. A week ago, she will forever be furious at how Blake quite clearly was using her for clout and leverage in her dealings with Justin's. She really hates that Blake would even think like that, let alone write the things that she did in that text, right? What does that have to do with Justin? Nothing. She's mad because Blake used her for clout and for leverage with Justin. Why would she do that? And then the source said, the damage Justin did by revealing those texts, the dragon's text most especially, and by his initial subpoena, even though he dropped it, is lasting and probably permanent. The truth is, the text wasn't even accurate. That's not the kind of friendship they ever had. Taylor would never think of herself as Blake's dragon or protector, or someone who would intervene on her behalf for starters. Blake is a grown woman who doesn't need anyone to do that for her. Secondly, she's married to one of the most powerful men in Hollywood. It was never a matter of Taylor believing she'd ever have to fight any battles for Blake. For her to see Blake use her name in that context was really hurtful. Valid, all valid. She's a grown-ass woman who, why would her friend need to intervene? The source also flagged how Swift, who had licensed her song, My Tears Ricocheted, to be used in It Ends With Us, a film adaptation of the best-selling Colleen Hoover novel, didn't put out a statement for Blake, noting that's not the kind of friendship they had. She didn't put out a statement for Blake because they weren't close. It truly sounds like their friendship was very superficial because she didn't put out a statement of support, because that's not the kind of friendship that they had. Taylor didn't even promote. It Ends With Us. When the movie first came out, before any of this drama was revealed, they said Swift's friendship with Lively was grounded in leisurely activities and the solidarity they shared for being mega wealthy rather than their professional engagements. They were baking pals, travel pals, home decor pals. And to be totally honest, billionaire pals, they got along because they each lived their lives with the sort of trappings and access and privilege that tons of money brings. It was nice to be with someone else who gets it and who absolutely didn't seem to need a thing from Taylor. Since she had her own millions, Swift was deeply wounded, and even if that heals, the scar will remain. What does that tell you about their friendship? They were friends solely because they were both rich and privileged, because they could relate to that lifestyle, and because Taylor didn't believe that Blake would need her for anything, wasn't going to exploit her or use her. So I like to hang out with her because she got it. She understood this life. We're both super rich, we're both very wealthy. I didn't have to worry that she might try to use my name for something or try to get something from me. But it doesn't sound like it was very deep. We like to go we baked sometimes. Sometimes we would travel together, but that doesn't sound like a friend, a best friend. They're making it sound like it was a very superficial relationship based on the fact that they were both wealthy, they were both uber rich, and they could benefit and that they could relate to each other. And certainly to a degree when you're friends with other celebrities, it certainly helps. You know, you don't have to use each other, but it does make you more famous in a way. It sounds just like a relationship of convenience, not of closeness. And if you're not in a friendship with someone where they would ever promote your work, but your friend is always promoting you and you're not in a relationship with someone, you're saying, we don't have that kind of friendship where I would support her, that means you're not that close. I think Blake believed they were closer than they actually were. I think Blake thinks a lot of things that are not true, but it's very clear that the only person that's continuing to bring up Taylor Swift is Blake. Blake actually told in an article with the Daily Mail, said that she was leaning on Taylor in August of 2024 because Taylor knows what it's like to go through criticism. and she was going to just put her energy and her time with her friend Taylor, the same woman that made all these claims about Taylor's involvement, and now she's running to a court and saying, "I want to know what they have from Taylor." And then she shares an email string where Taylor's own attorneys won't respond to them directly about their intervention, and Wayfair won't talk to them about it. So now they're like, "Well, tell us what you want." Responding to production matters that right now are irrelevant until they amend their complaint, and then saying to the court, "It's been 80 hours since I've heard from them. I don't know what the judge is going to rule. I don't know what he's going to respond to." Honestly, I really don't know, because right now it feels like he might rule in favor of everything that Blake does. And I will say that a lot of these filings have 100% hella confused the judge, which is why they did this to begin with all of these declarations, all of these motions, to compel. All of this pylon contributed to the judge being confused because he got oversaturated with the same message over and over and over and over and over again. Even though it wasn't true about Blake and Ryan not conspiring with Leslie Sloan, I'm going to tell you more about that because, trust me, there's a lot brewing on the horizon that I was made privy to yesterday, and it's far more dirty than you would like to think. The dirtiness isn't necessarily the judge. In this case, the dirtiness is Blake and Ryan and Leslie intimidating witnesses, tampering with them, in threatening them, any single person that could help. Baldoni is getting stalked and harassed and intimidated. What does that tell you? Brian Friedman wasn't lying. So what are your thoughts about this? Sheedy dismisses her two biggest claims. We're not going to talk about the judge. And now this whole Taylor Swift situation. And Taylor was clear today, we are not friends. Stop talking about me when she got a subpoena that had 30 different things that showed how much Blake represented her being a part of it, and she wasn't involved. And then says, I'm not going to support her because we weren't friends like that. Blake, you are a fraud. Please like and subscribe.